Yes, let's go. All right, welcome everybody. Just a few matters of housekeeping before we get into the beautiful universe of ISDS, Investor State Dispute Settlement. First of all, this is just a curiosity for me. For those of you who are enrolled in the master program here at the university, I don't know why I'm recording this, is French, you need to speak French, right? Like a student who doesn't speak French could not apply to that master program. No? Do you have to give, when you applied, you have to show something like some B2, okay, but then in terms of, I'm sorry, the course offerings, half and half, okay. Then going back to our business. I forgot my clicker, so I won't be moving up and down. I'll mostly be sitting here to move my slides. I would also will be, I recorded that video a couple of weeks ago because it didn't record, but I did not yet record the other small part where I talk a little bit about the exam. So I will do a recording of that. So for even those of you who are in class, you will still have a recording. I will use the same provision if I remember which one it was. Otherwise, you will get a second one, better for you. But I will do a little, 5-10 minutes recording of that. Are there any questions about what we've been talking so far about in investment law? This is our last session on international investment law. We're going to talk about the ISDS, which is the acronym that we usually use, that you will see everywhere, that stands for Investor State Dispute Settlement. So until now, we have really looked at the substantive part of investment law, right? So the first session, we looked at the scope of application of international investment law. We looked at the, overall structure of bilateral investment treaties. We looked at the definition of investment and investor that gives us, that give us kind of an idea of the scope of application, subjective and objective of investment treaties. And today you'll see that that's also important because it helps us determine the jurisdiction of the tribunal, which is a necessary step in investment arbitration. We then moved to the substantive part of BITs that deals with the protection and treatment of investors. So we looked at standards of treatment. In particular, we looked at non-discrimination, MFN, and national treatment, and we saw a little bit the differences with WTO law. We then looked at fair and equitable treatment, which is another standard of treatment, and then finally we moved to standards of protection, protection against expropriation and full protection and security. So today we're going to look at procedure, so what happens in case of a dispute. And already you will see that there are a lot of differences between this, the way in which disputes are settled in investment law and in WTO law. Just to give you a little bit of a sense of these differences, remember, WTO disputes, for example, are disputes between which kind of parties? Who can be a party to a WTO dispute? States. So it's an example of interstate or state-to-state dispute resolution, like cases before the ICJ or before the International Tribunal for the Law of the Sea. Now here instead, we saw that private parties, private actors, in particular industries, can have an important role. We saw that they can push their governments to bring a dispute against another state. Very often there is, private parties, industries behind a dispute, but formally, officially, it's only a state, and it's a state-to-state dispute. Instead, you will see this ISDS, Investor State Dispute Settlement. The name already suggests that this is a dispute settlement system not between two states, but between a private actor, foreign investor, and the state. And it's unidirectional. It is only the investor that can bring a dispute against the state. I mean, now you know what a bilateral investment treaty looks like. You know that it only has duties for states. So it makes sense. What kind of dispute would a state bring if the investor has no duties under BIT, right? So that's the first important difference. Another important difference is, let's see, the possibility to appeal. We saw in WTO law, for example, in the golden days, at least, of the WTO, you had the appellate body. So the decisions of the panel, which are called reports. So a report of a panel could be appealed to the appellate body. Now the situation is a little bit more critical. The appellate body is not really there. It might be, that's the hope that we all have, that it might, be recreated if the members agree. Otherwise, there is this other mechanism, the MPIA, but is limited. The membership is limited. But there was, in theory, that possibility to appeal. This doesn't exist, which, by the way, it's something unique in international law, because if you think about ICJ, ITLOs, or arbitral tribunals, even in interstate arbitration, you can't appeal a decision. You can't appeal a decision of an investment arbitral tribunal. Those decisions, we call them awards. You can't appeal it. There is another procedure, though, and we're going to talk about that. You can apply for an annulment. So you can try to get the decision annulled, which is a completely different thing, because there are only very specific grounds for annulment. We will see them, but the tribunal, for example, did not state reasons in the award, or the tribunal was not properly constituted. So there are very specific grounds. You can just appeal for, to review the law as you would do in WTO. So that's another important difference. A third important difference has to do with the consequences. We saw that in WTO law, if a state is found to have a measure that is inconsistent with one or more provisions of WTO agreements, it has to basically transform that measure so that it becomes consistent with the ruling and the recommendations. So either removing the measure altogether or modify it so that it's compliant with WTO law. Nothing else. Here, it's not about that. You don't have to change any measure, you have to pay. And we will see the awards have become really massive. In particular, in certain sectors, the energy sectors, we have some of the highest awards, but sometimes you have, 20, 30, $40 billion awards. So very different, the consequences if a state is found to have violated international investment law. Now, let me tell you, as you know by now, I like talking about where things are coming from. So the system that we have today, before we get into the details of ISDS as it functions today, where is it coming from? So it is fairly new compared to other dispute settlement mechanisms in international law, and compared to the substantive protection of foreigners and of foreign investors. In fact, although, first BIT is 1959, Germany, Pakistan, but I said this many times, we start seeing provisions about the protection of foreign property already in those, all the treaties of commerce and navigation and friendship from the, 18th and 19th century. So there was already the idea of protecting foreigners, but foreigners didn't have access to an international court or tribunal if something went wrong with the state that hosted them. We may have talked about this quite at the beginning, but let's imagine that this is the 19th century. You are from country A, you are going to country B to invest. You don't have access to investment arbitration. What can you do? You're operating there, you're living in this other country. What can you do? For example, can you sue the government that is hosting you in your own domestic courts? No? Immunity. So what can you do? Can you sue it in their own courts? You can't or you wouldn't? Excellent. So you can, but I mean, how efficient is that? What is the judge going to say? Is it going to say that his boss basically violated something? So very unlikely, in particular considering that a lot, especially for those countries where maybe the judicial system was corrupt or slow or not very efficient. So what you had was diplomatic protection. That basically was your only option. which means that you could go back to your government and say, look, I was there, I was having a great time, everything was doing fine, and then they did this to me. They expropriated my land, for example. Can you espouse my claim? Huh? The espousal of claim. Now, it's not super efficient either, or ideal for a foreign investor or for a foreigner in general. First of all, your home state can decide whether they want to espouse your claim or not. They might say, okay, or they might say, you know what, I have a good thing going on with this country. We are in great relationships. We are negotiating a bunch of treaties. I'm not going to jeopardize my relationship with them because your little land was expropriated. It's not worth it. So your government might even decide not to espouse your claim, first. Second, it might espouse your claim, but it might tell you, before, try domestic courts. And so we're back to square one, having to go through all these courts that will tell you that you're wrong. And even if your government decides, okay, I'm going to espouse your claim, it becomes your government's claim. It's no longer yours. You lose control, 100%. So it becomes an interstate diplomatic conflict, let's say, which your government will decide to deal with however they like, with economic measures, political measures, sometimes with military measures, and so on and so forth. So not amazing. But then slowly, a lot of countries, in particular those countries, capital exporting countries, so those countries that have their nationals, in other countries developing activities, they feel like they need to come up with better ways, a neutral forum for their nationals to find justice. And so we start seeing mixed claims commissions. We talked about them a couple of weeks ago when we talked about the NEAR case for the content of the minimum standard of treatment. Those were really the ancestors of modern investment tribunals. These mixed commissions, as the name suggests, they are established by two states, in that case was US and Mexico, to deal with disputes brought by Mexican nationals against the United States, US nationals against Mexico, and you could have others as well. So that's a little bit the idea that then became investment arbitration. So that starts happening. And then investment contracts, not so much treaties, but investment contracts start having arbitration clauses where they say, well, in case of a dispute, either you need to exhaust local remedies or maybe not, but at some point you need to have access to an arbitral tribunal. So we start seeing the reference in contracts to the possibility to bring the dispute to an arbitral tribunal. Now, the big step forward was actually done in the 60s in the World Bank by this man. Aaron Brosh, at the time, is a Dutch national. He was the legal counsel in the early 60s of the World Bank. And he came up with an idea. So something we didn't really talk about, but those years, late 50s, early 60s, there had been quite a few attempts to multilateralize investment law, substantive investment law. There had been attempts to say we need kind of like a global investment treaty with substantive rules that apply to everybody, to all states. It was in particular the OECD that was trying to do that, and developing countries didn't bite because OECD doesn't represent the whole world. So why should developing countries accept rules that have been created just by a few states? So those attempts failed. And Aaron Brosh, the smart guy, he was saying, you know what? In 1959, we have the first BITs. Countries are interested in signing BITs. Let's forget about multilateralizing substantive rules. Let's multilateralize procedural rules. So instead of having this super ambitious project of a multilateral investment code, let's just have some procedural rules that are global, that are multilateral. The substantive rules will be bilateral. It's fine. Countries will keep concluding BITs. That's fine. So they will deal with the substance of the protection and the treatment of investors bilaterally, but then we can create, a uniform global set of rules for the settlement of disputes. That's what he was thinking about. And he proposed that to his staff, and his staff accepted. And this was, there was a lot of convincing going on, in particular convincing developing countries. UNCTAD played quite an important role there. A lot of developing countries were nervous and were afraid that investors wouldn't choose them, wouldn't go to invest in their territory because they were afraid of their domestic courts. Their domestic courts were known to be corrupt, to be non-transparent, very slow, and so they were saying, you know what, investors might not come because they are afraid that if they come and if there is an issue, they have to deal with our domestic courts. So the way in which this project was sold to the developing world was to say, keep signing BITs with developed countries and have a little provision where you reference these new multilateral rules on procedures on arbitration. Investors will come because investors will know that if there is an issue, if there is a dispute, they will have access to arbitration through these multilateral rules. So it's a way to incentivize foreign investors. Whether that actually does incentivize, that's a different question. I do not have the answer to, but that was kind of the story that was sold to the developing world. And at the end of the day, they got a lot of support. And in 1965, you see Aaron Brosh in the middle, we have the adoption of the very famous ICSID Convention, Washington Convention, you can also call it, or ICSID Convention, which is the convention that established ICSID, which is the International Center for the Settlement of Investment Disputes. So this is 1965, entered into force 1 year later, in 1966. And then we start seeing BITs that refer the ICSID Convention, meaning the BIT has an arbitration clause that says that in case of a dispute, not only we're going to have arbitration, but we're going to have arbitration according to the rules of the ICSID Convention, which is kind of the goal. The goal was that, to create this multilateral convention, this center to administer disputes, and then to have all the BITs make a reference to it, right? The first one was this one, the Italy-Chad BIT from 1969. It's the first BIT that contains a reference to the ICSID Convention. You see, so any dispute between a contracting state and a person having the nationality of another state shall be subject to the jurisdiction of ICSID under the convention. And then you have also, this is quite interesting, there is also then the last sentence is on interstate disputes, so any dispute between the two states, and here it talks about diplomatic channels. Now, this is an old treaty. Modern BITs usually have a provision on investor-state dispute settlement, and then a provision on state-to-state, and usually state-to-state is not just diplomatic channels, they also allow arbitration there, and there is an arbitration clause there as well. Not through ICSID, because ICSID is only about investor-state. But so this is an example of the first arbitration clause that makes a reference to ICSID. And then again, this was just the beginning, because lots of BITs then started referring to ICSID, and as I will show you in a few minutes, not just ICSID, because ICSID is one way, it's one set of rules and one forum, one mechanism to settle investor-state disputes, but it's not the only one. It's the preferred one by investors, we'll see why, and I will mostly talk about ICSID today, but it's not the only one. So overall, the whole idea of investment arbitration, of investor-state arbitration, is to provide investors with a neutral forum, to depoliticize, because if you go to the domestic courts of the host state, there is the risk, diplomatic protection is very political. This is really a way to depoliticize any conflict, any tension between investors and the host state, and kind of to really, ensure the enforcement of all those rights, because you have all those rights, all those standards of treatment, protection, but if you don't have a neutral forum, then what's the point, right? So it was kind of to complete the overall protection that investment treaties give to investors. Everything clear so far? All right, a very important point which we need to talk a little bit about is the issue of consent. You know, probably, hopefully, that unlike in domestic legal systems, in international law, we do not have compulsory jurisdiction of courts, right? So there's always states have to give consent, which you usually find in treaties. Any treaty has a clause, a dispute settlement clause, where it's clearly indicated which court is going to be, or which mechanism of dispute settlement, is going to have jurisdiction. I may have even told you, but you may hear that WTO is the exception. There is some kind of compulsory jurisdiction within the WTO, in the sense that if you're a member, then it doesn't matter what the treaties say. The treaties do not have to refer specifically to the dispute settlement body, but the moment you're a member, you basically accept that any dispute that's going to arise under any treaty, even future treaty, you accept the jurisdiction of the DSB. So somehow you do give your consent when you join, right, when you become a member, but you kind of give a future consent also for future WTO multilateral treaties. So here as well, we need consent. And consent, so you usually have, our usual pattern. You have state A, state B. We have our friend in state B that goes and invests in state A. You have an investment contract between the investor and the state. You have the BIT or some kind of, you might not have, not every pair of states has a BIT, but you might have some kind of treaty maybe, let's call it BIT, between the two states. And then, especially if this is a developing country, capital importing, you may have an investment code, investment law, like a domestic investment law. So the consent from the state, you can find in all of these, either and all of these instruments. So it can be an arbitration clause in the contract, where the state agrees to arbitration clause in the BIT, or it can be a clause, an arbitration clause in the domestic investment code or investment law. Now, we will see, but most arbitrations are based on BIT, are based on the arbitration clause of the BIT. Some, we'll see some statistics on our contract claims, so they're based on the arbitration clause in a contract, almost none on the domestic law. So if we take the treaty as an example, the arbitration clause in the BIT, like the one that I showed you, that contains the consent of the state, because the investor has no role in the negotiation of a BIT, right? So that's how the state gives its consent. And that's basically an offer. For this offer to be perfected, the investor has to actually bring the dispute. So all the investor has to do is to initiate proceedings against that state, and that's when you have the perfection of this consent. So the state doesn't have to accept. The state accepts through the arbitration clause. That's it. And then all the investor has to do, depending on the condition, we'll see that arbitration clauses may have condition, is just to deposit a request for arbitration, and that's how the investor gives its consent. So arbitration clauses are extremely different one from another. If you remember when we talked about MFN, and in particular the risks of MFN, how some investors have been using MFN clauses to import other clauses, all the examples I gave you were about importing arbitration clauses, because you could have an arbitration clause in a BIT that has nothing to do with you, that is more favorable than yours. So there are a lot of differences in arbitration clauses, and states can get creative. They're going to give their consent, fine, but they can put conditions, they can limit the consent. So there's a lot of strategy going on in the negotiation of arbitration clauses. First of all, two important conditions that states can include in the arbitration clause is, this one is very typical, is the requirement for the investor to send prior notification of the intention to arbitrate. So before submitting the request to the tribunal, they usually need to notify their intention to arbitrate. It's quite typical. Another condition that is, you don't find it everywhere, but you find it sometimes, is a cooling off period between the notification of the intention to arbitrate and the submission of the request. It can be, 3 months, 4 months, 6 months, 12 months, 18 months. It can be different in different treaties. And the whole idea is to try and solve the disputes amicably without going to arbitration. That's usually the goal in any, whenever you're looking at any dispute settlement system in international law, there is always the tendency to try and encourage amicable settlement before going to court. WTO also had a period where countries had to, consult and try to find the solution. Again, not all treaties require it. And if you remember, the Maffezzini case was precisely about that, right? The Spain-Argentina BIT required 18 months cooling off period between the notification and the submission of the request. Maffezzini was unhappy, and the investor immediately submitted the request. The state raised a preliminary objection, and then the lawyers found this crazy other BIT with Chile that didn't provide for a cooling off period, and they were successful. So you can have a whole palette of different formulations. Just to give you an idea, this is just an example from the German model BIT. So you see, for example, there, should as far as possible be settled amicably, because that's really the goal. The goal is we want to avoid arbitration. Our goal is that countries, foreign investors, they can deal very peacefully, very amicably with their issues. But if we can't, then you can go to arbitration. So here, the cooling off period is 6 months. So 6 months, and of course there it's only the investor that can request, because the state has already given consent by drafting this specific clause. And in fact, look, in the blue part, the two contracting states declare that they unreservedly and bindingly consent to the dispute. So the state gives its consent here. But again, you can put this condition. So prior notification, cooling off period is an example of conditions that a state can introduce in the arbitration clause. Another condition is, it's very rare today. It was quite traditional in the past, is to require the exhaustion of local remedies. So there are some old BITs that require that. Before submitting to arbitration, you need to have tried with domestic courts of the host state. Sometimes it's an open-ended requirement, condition. Sometimes it's limited in time. You need to have tried in domestic courts for 18 months. 12 months. After that, if there is nothing, okay, then you can go to arbitrate. But again, you will hardly find it today. You would find it mostly in old treaties. Then another important part that you always have you have all these conditions, and then very important part you have in an arbitration clause is the list of fora and rules that can be used, because as I said, ICSID is very much used, it's the most popular, but it's not the only one. So here, for example, under the German model BIT, and here as well, they're very different from each other. The investor has a lot of options. You see, these are all the options that the investor has. It can decide to go to ICSID. Now, to give you a little bit of background on ICSID, and it's really the choice, in this case, it's just the choice of the investor. One of the following of the investor's choosing. It's not always how it's drafted, but in this case, the investor can say, I will make my choice. And there's a lot of strategy going on. A lot of the work that law firms do at this stage is to advise the investor as to which forum and which rules to choose, because they are very different and they can be more or less beneficial. So ICSID, you have, well, first of all, ICSID is just about investor state. So it's in the center is an institution that it's only there for, it's specialized in investor state. There are other institutions, one that is not listed here, but that can be used, is the PCA, the Permanent Court of Arbitration. Now that's used for both interstate and investor state, but ICSID is just investor state disputes. we will study a little bit the rules, and it has a very detailed set of rules. It really disciplines everything about the procedure from the first moment until the end. So it has a very precise set of rules. It's an exclusive set of rules, meaning that if you choose ICSID, you can only apply ICSID rules. It also comes with a lot of institutional and administrative support, unlike other rules that don't have any support. So you have the center, you have ICSID that helps you administratively and as an institution. That means that it gives you the venues, the facilities, you go to Washington. That means that all the financial arrangements are managed by ICSID. So it's kind of easier. It means that the secretary of the tribunal is going to be a lawyer from the Office of the Legal Counsel of the ICSID Secretariat. Well, if you use other institutions, you have to do all these things on your own. You don't have a center. I work a lot as a secretary of tribunals. Obviously not ICSID, because I'm not an ICSID staff lawyer. I do for ICC, and then it's the tribunal that hires, out of their own pocket, a lawyer to be the secretary. Nobody provides them with it. Instead, here, everything is provided for. The additional facility, the ICSID additional facility, and then we will see later, there are quite a lot of other differences. In ICSID, for example, I told you earlier that you can't appeal in general an investment award, but you can get it annulled. Annulment procedure under ICSID are also regulated by ICSID, while outside of ICSID, it's the domestic courts of the country where you have the seat of the arbitration. So there are a lot of important differences. But we're going to get back to annulment. Then you also have additional facility. Now this is quite interesting. In order to be able to bring a dispute to ICSID, both the host state and the nationality and the state of nationality of the investor have to be parties to the ICSID convention. But what, for example, if, let's say that Germany signs a BIT with, I don't know, Switzerland, no, difficult, with Nigeria, and they both are parties to the ICSID convention, but at some point, Nigeria decides to get out of the ICSID convention. You can still use the additional facility. So the additional facility allows you to use the institutional structure of ICSID, but when one of the two states, either the home state or the host state, is not a party to the convention. The rules are different, though. There is a specific convention on additional facility. So you can rely on the institution, but it's a different set of rules. This had been done in particular to allow NAFTA disputes, because for a very long time, the only NAFTA party that was party to the ICSID convention was the US. Canada joined, I want to say 2013, something like that, and maybe around 2018, I think, Mexico. So for all that time, I'm not saying that officially that was the reason why, but it really helped to have NAFTA cases under ICSID additional facility. Then you have another option. You can use, so outside of ICSID, you can use in terms of rules, the rules of UNCITRAL. This is another set of rules, completely different. UNCITRAL rules, we're not going to go through all the different characteristics, but in general, they leave more freedom to the parties. So the ICSID are really a little bit more constraining, but they have other advantages. Instead, UNCITRAL give a little bit more freedom, and UNCITRAL rules, can be used in several different settings. For example, in this case, you can apply UNCITRAL rules if you have an ad hoc arbitral tribunal or an individual arbitrator. Other arbitration clauses will tell you that you can also do UNCITRAL rules and PCA. So you can actually use the institutional support of the Permanent Court of Arbitration, asking them to apply UNCITRAL rules. So UNCITRAL rules you can apply in many different fora, while when you go to ICSID, you only apply ICSID rules. That's the big distinction. Or you can use the rules of ICC, the London Court of International Arbitration, Stockholm Chamber of Commerce. In all of these non-ICSID, so with ICSID you are stuck with Washington as the seat of arbitration. In all these other non-ICSID disputes, you can choose, the two parties can agree on the seat of arbitration, which is also going to be, which can be, usually it's London, Geneva, Paris, Singapore, which is important. That's another strategic decision, because if then you want to ask for an annulment, it's going to be the domestic court of the seat of arbitration that decides on the annulment based on their domestic law. Instead, ICSID, there is a whole procedure within ICSID to annul. So you see, there's a lot of strategy that goes on in the choice. It's an important, very important choice for the investor. Now, in this clause, as we saw, the investor can choose any of these. So you will have the lawyers of the investor, then go through all the different options, and then we'll advise the investor, you should choose this. Fine. Sometimes it's trickier. Remember, we saw in the I talked to you about the Garanti Cosa crazy decision where they imported another arbitration clause that allowed the investor to go to ICSID on its own, while the applicable treaty, UK Turkmenistan, didn't allow, based on the UK model BIT. UK model BIT, there is a whole list of options, but the choice has to be agreed upon by the investor and the host state. That was the case, the whole issue in the Garanti Cosa arbitration, that the investor could only go, for example, to ICSID if there was an agreement with the state. If there was no agreement, in this case after 3 months, the dispute has to be arbitration under UNCITRAL rules. So the whole problem in the Garanti Cosa dispute was that the investor went to ICSID without agreeing with the state, and then imported a clause from another BIT, which was more similar to the German model BIT, which allowed investors to go to ICSID directly, and the tribunal said yes. I don't want to go back to that, because then I'm going to just vent for 10 minutes. But this is just to give you an idea of all the different. So from a negotiation point of view, it's very interesting. Arbitration clause is very important, because it really creates a very different scenario if a dispute arises. Everything clear so far? All right, I'm gonna tell you a little bit about the difference between contract claims and treaty claims, then we take a break, and then we go deep into ICSID. So I told you earlier that you have arbitration clauses in the contract, you can have it in the domestic law and in the BIT. Again, very, very rare. I actually don't know of any. I mean, I'm sure that there is at least one, but I've never seen personally or studied a case which was brought under a clause in a domestic law. It's usually arbitration clause in the contract, and usually then the investor, relies on the arbitration clause in the contract to bring a contract claim, meaning arguing that the state has violated some of the rights in the contract. Or you can base and by the way, dispute settlement clauses in contracts, they don't always refer to arbitration. In BITs, 100%. But in contracts, sometimes they refer to domestic courts, sometimes domestic courts plus arbitration, sometimes arbitration, so there's a whole variety. But you can also rely on the arbitration clause in a BIT to bring a treaty claim when you're arguing that the state has violated one or more provision of the treaty. As I said, treaty claims are way more common. So here you have a little bit of a breakdown. You see that 59% is just BITs, but then if you also add the Energy Charter Treaty and other treaties and so on and so forth, you get to, what is it? Well, the rest is 14 is contracts, investment laws is 7, 21, right? So 79%, yes. 79% is treaty claims, treaty-based arbitrations. And then you have 14% that is contract claims, and then actually not so bad, 7% based on investment laws. But the vast majority is based on treaties. Now, it's an important distinction to make, the one between treaty claims and contract claims, because, in particular, when it comes to the applicable law, if you bring a contract claim or several contract claims on the basis of a contract arbitration or dispute settlement clause, the applicable law will be primarily the domestic law of the host state that regulates that contract. I mean, it will be the applicable law that is set out in the contract, which more often than not is first of all the domestic law of the state, and then in second instance, in a supplementary way, international law. Instead, in a treaty claim, international law. Domestic law can help, to deal with some facts and so on, but it's quite important to distinguish because the applicable law is not the same. Contract claim, it's the applicable law that is identified in the contract, which more often than not is first of all the domestic law of the host state. If it's a treaty claim, it's international law. It's the treaty provisions and Vienna Convention and so on and so forth. Now the big question is, if an investor brings a treaty claim, so relies on the arbitration clause in a treaty and argues the violation of several provisions of a treaty, because there is also a contract underneath, let's say, can the tribunal, or better, is the jurisdiction of the tribunal limited to the treaty claims, or can it also extend to contract claims that the investor might make? Now, for a long time, there was, many would say absolutely not. It's limited to the treaty claims. Now, the approach is a little bit different. It depends on the formulation of the arbitration clause. That's why it's so important. Arbitration clauses are crucial, because in the arbitration clause, you can already guide the tribunal as to what is the extent of its jurisdiction. If you have, again, German model BAT, if you have such a broad arbitration clause whereby disputes concerning investments between a state and the investor of the other state basically fall under the jurisdiction, then any dispute, any legal disagreement basically between the investor and the state, it doesn't specify. So ideally, a contract claim is related to a dispute on the investment between investor and state. So with such a broad clause, we could say that the tribunal could have jurisdiction to also look at contract claims. Parenthesis, very often there is one action of the state which might be at the same time a violation of a treaty provision and a contract provision. So there is also a very blurred line between contract claims and treaty claims. But then look at this. Energy Charter Treaty, very different. Because here the jurisdiction is related to a dispute which concerns an alleged breach of an obligation under Part 3. So only in case of the violation of an obligation under Part 3 of the ECT, which contains all the substantive standards of treatment and protection. So in this case, no. The jurisdiction doesn't extend to contractual claims, only to claims of violations of treaty provisions, and not just of treaty provisions. I'm not a fan of this formulation, only of the provisions that you find in Part 3. There have been, I was very much involved in the whole process of modernization of the ECT, which went nowhere. A lot were arguing that it was already very good from a climate change perspective. I was looking at it, and a lot of people, a lot of countries were saying, no, but there is a provision on the right to regulate, which can be used to defend climate change measures. Yes, it's not in Part 3 of the agreement, so that provision doesn't fall under the jurisdiction of the tribunal. So this one is an example of a very narrow jurisdiction, only not even just treaty claims, but only alleged violations of specific provisions of the treaty. And then last point on claims, you can have this, which we call umbrella clause, where you basically have a provision that tells you that the states, the contracting parties, have to observe any obligations that they may have entered into with nationals of the other state. So they have to observe contracts. So even if we say that a tribunal that is basically created on the basis of an arbitration clause in a treaty should focus on treaty provisions, this reference to the obligations that the states have in contracts allows the tribunal to bring in all those obligations as well. We call it umbrella clause because it kind of covers a lot of stuff, which any other obligations coming from any contract or promises, legal promises that the state may have made to the investor. Okay, let's take 15 minutes break. At 3:15 we come back. In case any of you has questions, I have a meeting at 4:05, so I won't be able to stay after the class. So if there's anything urgent, pressing, you can come see me now, or we see each other next week anyway.
Yeah, I'm writing my thesis on this. No, so that's just a couple of yeah, so there's a seminar on investment law that I guess didn't so the seminar is about sustainable development I'm using Red Do you think, after you mentioned your own position, what do you think the MSTs, the customer international like for example, legitimate overstatement. Do you think further improve to show, for example, representation of culture representation? Actually, yeah, my second question was about it's about the I'm not sure if I will be actually in Switzerland until so I have an exam in France, so on the second
I haven't told me, maybe believe me, I also want to
Thank you very much. Yeah, it usually takes like, it's like window.
Yeah, but I don't know. And I'm asking those people a lot of But it's okay, we're gonna get through. All right. All right, so we saw, what did we see? Consent. We saw a few different formulations of arbitration clauses. We saw, and by the way, just to clarify, I had a very good question from one of your classmates. So the issue of the seat of arbitration only applies in non-ICSID arbitrations, because then you can choose the seat of the arbitration and the award, because then has repercussions on the recognition, enforcement, and annulment. Instead, when it comes to ICSID, there is no seat. Physically, it's the ICSID facilities in Washington, although now they're opening up ICSID in Singapore, That's interesting. They have already opened the PCA. PCA now has a headquarter also in Singapore, or it can also be online sometimes. But there is no seat as such, in the sense that, again, the seat is important because it's what determines the domestic court and the domestic law that will apply to recognition, enforcement, and annulment. But all of this, we will see it, is internationalized in ICSID cases. It's under ICSID, so it doesn't matter. So consent, arbitration clauses, distinction between contract claims and treaty claims. Now we go on ICSID. So I'm just going to tell you a little bit about the ICSID rules. Again, we would need probably a whole semester just on going through all the different rules of arbitration. In general, ICSID was established in 1965 with the Washington Convention, or ICSID Convention, which entered into force in 1966. The center, you have the preamble that gives you a little bit of a sense, the preamble of the convention, of what the objective and the purpose of ICSID is. So, economic development, in particular, favoring foreign investments for the purpose of economic development and providing, a neutral forum to settle disputes. And then it's very important, just between investor and state. So there is no possibility to have interstate disputes at ICSID. You have the parties here. There's 158 parties, and if I'm not mistaken, should be about 165 signatories, so countries that have signed but not yet ratified. So here you have a sense. In blue, you have the countries that are parties to ICSID, and so that can rely on the ICSID Convention. Thinking, though, that, again, if you have a dispute where either the host state or the state of nationality of the investor is not a party, but the other one is, you can use the additional facility if the treaty identifies the additional facility as one of the fora. As of, I think, 2024, so I'm a little bit behind, there were 991 disputes, so now maybe we'll be a little bit over that have been brought to ICSID, so quite a few. And you can see there's a big spike starting from the year 2000s. When I say 991 cases, I mean all types of cases. Regular ICSID, additional facility ICSID, which are quite a few. Conciliation, it also allows for conciliation, so also those. Something that is very important about ICSID is that it has its own rules, its own procedural rules, and they are exclusive. You go to ICSID, you can only apply ICSID rules. Instead, you go to the ICC, you go to the PCA, you go to another institution, you can, for example, ask to have UNCITRAL rules. In this case, no, you can only apply ICSID rules, and it has very detailed rules. So if you get, it's not very big itself, it's something like, it's a little booklet, something like this, but it has very detailed rules. You have the convention, which sets general rules about, arbitration, investor-state arbitration, for example, the jurisdiction of the center. We'll see that provision. And then important is the last one. You have we're going to look at some of those rules, the rules of arbitration. You also have the rules for the conciliation proceedings, and then you have rules, institutional rules, financial regulations. Those are just important when you're working for the tribunal, because you need to know how the financial arrangements work and all those things. But very important for us, for you, is the convention, and then the rules of procedure for arbitration proceedings. And if you can see, these are the rules of the arbitration rules. You don't have to, of course, know all of these rules. I will just show you a couple, but it details everything. We will go through together through an arbitration proceeding, and from the establishment of the tribunal, every single step has its own rules. Every single step up until the annulment, because as I mentioned, annulment is done under ICSID, not under the domestic courts and the domestic law of the seat. Something very important when it comes to the convention is the jurisdiction. So all of this matters if the center has jurisdiction. So if you can actually bring the case to ICSID. And there are 5 conditions for jurisdiction. This is Article 25. It's an article that we have already seen briefly, but here you have your five conditions. So the first one, there has to be a legal dispute. There has to be a legal dispute. Of course, there is no definition of what a legal dispute is. Surprise. But it has to be a dispute. So there has to be a certain level of disagreement between the state and the foreign investor, which has to have some practical consequences. It can't just be a theoretical, disagreement on principle. And it cannot just be a general grievance. I want to complain about general behavior. No, you need to be able to illustrate in legal terms what your disagreement is with the state. And it has to be a legal dispute. So it has to be a dispute, that has to do with the existence and the extent or the scope of a certain legal right or obligation, or with the nature and extent of reparations due in case of breach. So kind of classic definition of what a legal dispute is, let's say. And the dispute has to exist at the moment of the request. So it can be a dispute that was in the past, but it has been solved, and you can't request arbitration for some future dispute that you think is going to happen. Arising directly out of an investment. So, who remembers? How do we determine if there is ICSID jurisdiction in terms of the investment? You remember what kind of activity does it have to be for it to be an investment, for there to be jurisdiction of, yes?
There needs to be an investor?
Yes, investor, but let's focus on investment.
It can't be a one-off transaction. It cannot be a one-off.
Okay, cannot be a one-off transaction, but that's because, who told us that? How do we know that? Yes.
It is the double barrel test, so treaty definition of investment and its definition under this test.
Very good. So, and that is the one that you mentioned is one of the elements of the Salini test. So you need to first look at how the applicable treaty defines investment, which usually is enough in non-ICSID cases, but because ICSID convention tells us that it has to arise directly out of an investment, it also has to be an investment under the ICSID convention. The ICSID convention does not define investment, so thankfully the Salini tribunal has come up with the beautiful Salini test. Financial contribution, duration, risk, and some tribunals accepted, some don't, contribution to the economic development of the host state. Then you have an investment. And the dispute has to arise directly out of the investment. So there has to be a link, a connection between that economic activity, the construction of a highway, like in the case of the Salini case, and the dispute. The government revokes the license to construct the highway. There is a clear link between my investment, which is building the highway. I am revoke the license. I can no longer build the highway. There is a clear link. So you need to have this clear, direct link between the investment and the dispute. Then it has to be between a contracting state and a national of another contracting state. So both the host state and the state of nationality of the investor have to be parties to the convention. If, I mentioned earlier, if one of them isn't, ideally, if the treaty allows it, you can use the additional facility, which is another set of rules. Now, something that we had talked about, remember that we talked about dual nationals, which matters in particular when we're talking about investors that are natural persons? Yeah, like individuals, sorry. It can be, there are some individuals that have multiple nationalities, And we said that in general, what matters there is the effective nationality. And in non-ICSID arbitrations, if, for example, our investor has the nationality of B and has also the nationality of A, but the effective nationality is the nationality of B, you are a foreign investor in non-ICSID cases. Here, any natural person who had the nationality of a contracting state other than that of the state party to the dispute. So in ICSID arbitrations, if you have, let's say, two nationalities, and one of them is a nationality of the host state, even if it's not your effective nationality, you, before investing, you didn't even know the state existed. You cannot, you're still not considered a foreign national, so it's more strict from this point of view. So of course, if you are in this situation as an investor, you can't choose ICSID because there's no jurisdiction there. And then consent in writing, and in writing, it's the arbitration clause, and it's the written request for arbitration. Voila, the writing of the state and the investor. Okay, so far jurisdiction, 5 conditions, okay? So it has to be a legal dispute. It has to arise directly out of an investment. It has to be between a contracting state and the national of another contracting state, so both have to be contracting states of the convention, and the consent has to be given in writing. Now, an important difference, as I mentioned earlier, between ICSID arbitration and non-ICSID arbitration has to do with the recognition, enforcement, and annulment. Because recognition, enforcement, and annulment are fully internationalized under ICSID, which is not the case in non-ICSID arbitrations. So, for example, when you apply UNCITRAL rules. What do I mean? The award of a tribunal is binding and final. It can't be appealed. In an ICSID arbitration, the award of the tribunal is automatically and immediately recognized by all the other parties to the ICSID convention as if it were a decision of their own domestic courts. Automatically recognized. They cannot interfere. Non-ICSID arbitration, there is a specific convention that applies to recognition and enforcement of non-ICSID arbitration. We are not going to go into that. It's called the New York Convention. We are not going to look at that, but there is a specific convention. And under the convention, in non-ICSID arbitration, domestic courts can decide not to recognize an award. And the New York Convention sets the ground. Usually it's for public policy reasons, or big procedural flaws, or things like that. But courts have the right to say, I don't recognize it. With ICSID, automatic recognition. And in theory, automatic enforcement. Now, whether you will be able to actually enforce, meaning you will be able to get your money back, that's a different story. Because if you ideally, you're an investor, you win $200 million, the state comes and pays you. That's an amazing ideal situation which almost never happens. Usually you need to go and find your money, which usually you do by trying to seize the assets of that state in other countries. And in order to seize the assets of the state in other countries, you need to get permission from the courts of that state. So that's there, even in ICSID arbitration, states have that role, but that doesn't mean that, but they have to recognize the award. Then they have to give you permission. For instance, if you say, I want to seize the embassy, no, you can't. That's a government building. I want to seize the central bank, you can't. No? Only commercial assets. That, again, we are not going to get into this because this could be another whole semester course, the problems with enforcement. But just remember that ICSID internationalizes everything, and the awards are automatically recognized by all the parties to the convention. While, again, in non-ICSID arbitrations, domestic courts can refuse to recognize an award. And ICSID, we're gonna look at that in detail later, also internationalizes annulment. So awards are final, you can't appeal, there isn't a supreme body to appeal, but you can apply for annulment. And if it's an ICSID arbitration, it's ICSID that takes care of the annulment procedure. They set up a committee of 3 people, and there are specific rules that we're going to look at that tells you when you can annul. Very limited cases. Instead, in non-ICSID arbitration, this is fully domestic. So you chose as the seat of arbitration Singapore. You want to annul, it will be Singaporean courts that will decide on the annulment applying Singaporean law. That's why you need to be careful in choosing your seat. You might know that, and that's why that's why these cities are chosen, because they have systems that are quite favorable for investors. Although it depends, It depends. So we're gonna talk more in detail of the annulment procedure under ICSID, but this is an important difference, and all these differences play an important role. And again, this is a big part of work that lawyers do. Like, in case you want to get into this business, there is of course the whole part of working for the investor or for the state in the context of an arbitration, but there is the whole part of structuring the investment. Where do I set up my headquarters? How do I structure? How do I benefit from? So the legal part of all that treaty shopping, it's part of what lawyers do. And even before the dispute starts, selecting whether to start a dispute and in which forum, this is an important decision. So it's a lot of what lawyers do. Now I want to kind of take you through an ICSID arbitration procedure, step by step. So this is all the rules. Again, we're not going to look at all of them. I will just show you a little image and we go through the procedure. If you're super interested in this, you can have a look at the rules. They're not very complex. It's a little boring procedure, but they're important. I shouldn't say that. This is, I think we also uploaded this document. If not, we will, because it's nicer than in a slide, but this is a little bit the whole process. So it all starts with submitting the request by the investor. Again, sometimes there was a notification, maybe the cooling off period ends, the investor and the state couldn't come up with a solution, and so there is the submission of the request. Something maybe that I could have mentioned earlier, because I will talk about this now. There are a few important bodies or people in the context of ICSID. You have the Administrative Council, which is the governing body of ICSID, which has a representative per participating country. Which has a chairman. And the chairman is quite important because it also plays some important roles in the context of the procedures. For example, it's the one that the Secretary General receives the request, but the chairman is the one that, in case the parties can't agree on one or more arbitrators, the chairman comes in and selects an arbitrator. So you have this Administrative Council, you have the chairman, and then you have a secretariat with the Secretary General, and then the staff, including those lawyers that act as secretary of individual tribunal. Because again, I mentioned this already, but ICSID is not a tribunal itself. It's just an institution, it's a center which offers administrative and financial support. But then a tribunal has to be created, and we're going to see how that's done. So our investor submits a request for arbitration with the Secretary General, and this request has to contain, what you would expect: the facts, the basis for jurisdiction, the main claim, the main applicable law, the parties, and so on and so forth. There is a screening, and the Secretary General and its office decide whether to register or not the request. Now, generally, the request is registered unless it is so obvious that it's outside the jurisdiction of the center. For example, it's immediately obvious one of the parties is presenting itself as a country that is the investor is presenting itself as having one nationality, and the nationality is not party. It's so obvious, right? So in that case, there's going to be a refusal of registration. Otherwise, it's registered. Now, the fact that the Secretary General accepts to register the request doesn't mean that the tribunal has jurisdiction. It just means there isn't some blatant, super, obvious reason why this dispute shouldn't go on. But the respondent usually, so the state, will have the chance to present objections to jurisdiction, and the tribunal will have the right to decide yes or no whether they have jurisdiction. Also, it has no impact on any decision on jurisdiction. Then we get to the composition and constitution of the tribunal. Generally, tribunals are made up of 3 individuals, 3 arbitrators. You can also have options with 1 arbitrator, very rare. And generally, each party nominates 1 arbitrator. So the investor nominates 1, the state nominates 1, and then the 2 arbitrators together nominate the president of the tribunal. If in 90 days they don't manage to do all of this, then the chairman comes in, consulting the parties, but can select their outstanding arbitrators. The whole idea is not so much to give power to ICSID or to remove freedom of choice from the parties. The goal of this is to avoid that one of the parties, the state, who is not maybe super excited of the case, will stall and will be non-cooperative by not nominating their arbitrator. So if you want to play that game, fine, the chairman will come in and will nominate someone which you may not like. So the idea is to make sure that both parties, do their job and nominate their arbitrators. They get appointed, and then the tribunal is constituted. When it comes to the requirements for the arbitrators, they can't be from the nationality of the host state, home state. But other than that, there isn't much. In terms of requirements, you don't need specific degrees or specific bar associations. You need to be a renowned expert in your field, investment, trade, commerce, finance, and you need to be of a certain ethical, have a certain ethical behavior, and so on and so forth. But there aren't otherwise very rigid requirements. ICSID keeps a list of arbitrators, but you can also appoint an arbitrator that is not, so the list is helpful, in particular if maybe you are a small state that is the first time you already have a list of people that are good at this, but you can also nominate an arbitrator that is not in the list. Once the tribunal is constituted, it stays the same, right, for the whole procedure, unless extreme situations, death, incapacity, resigning, or if if there is a recusal, for example, of a member, or if one of the parties ask for a member to be disqualified, usually it's for conflict of interest because they discovered that it was the grandfather of somebody in the other team, or there is some conflict of interest, previous working together, previous some relationship, or you discover that they didn't have the ethical requirements that they needed. So there can be a situation of a request to disqualify. Well, okay, then we start with the actual procedure. You have a first session with both parties where usually all the procedural questions that will determine the whole arbitration are defined. So who are the representatives of the parties? And you need, very, very basic, you need to know, so who are the lawyers? Who are the names of the lawyers? What is going to be the language? Are we going to record our sessions or not? What is going to be the procedural calendar? What are going to be our rules when it comes to evidence? So everything that is not in the ICSID conventions, there's a lot of other elements that of course are going to be different in each case. That's what you need to kind of decide in your first session. And then it starts with the written procedure. The written procedure begins with a memorial submitted by the claimant, so the investor, followed by a counter memorial by the respondent state. Usually there is then a second, usually the written phase has two moments. It's rare that it's just memorial, counter memorial. Usually you have memorial, counter memorial, reply by the investor, rejoinder by the state. So you actually have two moments where each party can, state their claims. In the memorial, again, the complainant has to introduce the facts, what are their claims, what is applicable, what are the legal, provisions that have been violated, and it has to also contain a submission, and the counter memorial as well, meaning a suggestion to the tribunal to what should be their decision. The counter memorial is also the last moment that the respondent state has to bring a jurisdictional objection, to challenge jurisdiction, to say, I don't think you, tribunal, have jurisdiction because it's not an investment, because this is not a foreign investor, what have you. If there is an objection regarding jurisdiction, the tribunal has a very important decision to make. They can decide to bifurcate the proceedings, so to first have a set of proceedings just to decide on jurisdiction, and then if they decide that they have jurisdiction, then they move to a separate phase just on the merits. So you're going to have a decision on jurisdiction, and then you have the second phase that begins, and then you're going to have the award. Or they can decide not to bifurcate the proceedings and to just have one phase and decide everything together. It's 100% up to the tribunals. The parties will give their opinion as to what the tribunal should do. Often the tribunal consults the parties on that. And there are many, many factors that are taken into account when looking at bifurcation. And I mean, it's every case that I've seen personally, there is always a jurisdictional. I mean, it's very typical that you find jurisdictional objections. And it's a very important decision. And it's a decision where you look at a lot of different factors. For instance, to what extent, for example, is the analysis that you're going to conduct very much overlapping? So by looking at the jurisdiction, are you going to look at a lot of facts and elements and provisions that you also need for the merits? So is there a big overlap? Are the witnesses the same? Are the experts the same? If that's the case, you might want to do everything together, because otherwise there's going to be a lot of repetition, a lot of waste of time. Is the objection to jurisdiction clearly very weak? Let's do it together, because there is a good chance that there is jurisdiction. And if we have a whole procedure just for jurisdiction, we're going to waste phase, because that means that the whole procedure will be longer. Is going to be very problematic, very damaging for the investor, for example, if we delay too much addressing the merits? So these are all factors that we take into account when the tribunals take into account when deciding whether to bifurcate or not. If they bifurcate, usually there doesn't have to be an oral phase in the jurisdiction phase, but if the parties ask for it, the tribunal can decide to have it. But if you bifurcate, you have your jurisdiction. If the tribunal decides that it has jurisdiction, then you move to the merits and you have again submissions and so on. Otherwise, you proceed with the second phase of the written, reply, rejoinder, and then with the oral phase. In the oral phase, you have oral hearings. That's when, and by the way, in the written procedure, you have the different, the memorial and counter memorial can be Sometimes they can be, I've seen very short ones, like kind of almost embarrassing ones, like 25 pages, where there's not much. And then you see some that are more than 100. And then you see exhibits for thousands of pages, which are painful to read. They won't hire me again. After that, the oral procedure, you listen to the witnesses, you counter, you do the examination of the witnesses, of the experts. Every party gets to examine everyone's witnesses and experts, and so on and so forth. And then you get to the end of our procedure. Deliberations, which are privately, just the members of the tribunal. Their reasoning is secret, but you need to indicate your reasons, let's say. So the deliberations are secret, let's say, but then the award has to contain the reasons. It's very important. It's one of the grounds for annulment if you don't indicate the reasons for your award. The award can be with a unanimous tribunal, but not always the case. You can have dissenting and separate opinions, but dissenting opinions mostly. You just need a majority. You need two members. And it's circulated to all the parties, and it's binding. It becomes binding. As I was saying, they can't appeal, but they can apply for annulment. There's a time limit. I think it's 120 days, if I'm not mistaken, roughly that, from when there is the dispatch of the award. And I want to show you the grounds for annulment under ICSID. So as I mentioned, annulment is internationalized under ICSID. So any party within this frame of time can ask for an annulment. A committee of 3 people is set up under ICSID, and they decide on the annulment. Again, no NICSID cases, you go to domestic courts. So you will see, if any of you decides to do your thesis on investment law, work in investment law, and you go on the websites where you find all the cases, sometimes you will find annulment decision by ICSID ad hoc committee, sometimes it's going to be by a Singaporean tribunal, a London court. That's why. These are the grounds for annulment. These are the only cases, so very different from appeal. You can appeal a panel report because you think that the legal reasoning was wrong. That's not the case with the annulment. And this is an exhaustive list. The tribunal was not properly constituted. I'll give you an example. There was a case, it was quite big because it had to do with a Swiss, you can find it on the news, it was everywhere, with a Swiss arbitrator earlier this summer. There was a big case called Rockhopper Italy, brought by British investor against Italy. It was an energy case. They had, basically Italy had not renewed some concessions for fossil fuel production for this investor. And the investor brought the case and the investor won, like $200 million award or something quite big. Italy asked for annulment, and the committee found that they decided to annul the award a few months ago because the tribunal was not properly constituted. What had happened? One of the arbitrators had not disclosed that he had been, in the 90s, he had been criminally prosecuted by Italy. Oh yeah. And so regardless of how that procedure ended, that was irrelevant, but the committee thought that this person, couldn't be trusted to be an independent judge in this situation. And so they did, so that's an example of a committee finding that the tribunal was improperly constituted. If the tribunal has manifestly exceeded its powers, if it was fairly clear, for example, that the tribunal had no jurisdiction, or if you have a tribunal where the jurisdiction is limited to treaty claims, because it's like that article from the ECT, they can only judge claims brought under Part 3, and instead they also judge other things, excess of powers. Corruption. I don't know of any case where somebody has raised corruption successfully. Very difficult corruption, which is good. It's a good thing. Serious departure from a fundamental rule of procedure. Now, this mostly you find it if there has been a clearly like favoritism for a party by a tribunal, discriminatory treatment in the way in which you never, for example, and this is in ICSID and outside, but if one of the parties asks for something, you should always ask the respondent or the other party to comment, to give their view. You can't just say okay. So if this is constantly not done, so always favoring one party to the other, that can be a serious departure. So it has to be a serious departure. No, if you go a little bit, you don't really follow procedural rule, but it's not a serious departure and it's not a fundamental rule, it cannot be annulled. I don't know what could be the case that you're supposed to send all the documents or any procedural order via email, and then within 4 days upload it on the online database that everyone can access. You upload it 6 days later. You are violating a rule of procedure, but it's a small departure of a non-fundamental rule. Okay. And if the award has failed to state the reasons. So this is also, again, you need to always first of all, you need to address all the questions, even if it's to dismiss them, and you need to state the reasons. And this is another important provision that tells you, that's really about the award. In writing, it has to deal with every question and it has to state the reasons. Everything clear? Now, in the last 6 minutes, I will tell you about the crisis of ISDS, which would deserve hours. But I shared with you this document I think it's from IISD, which is the International Institute for Sustainable Development. They're very much involved in the discussions on the reform. So we talked about the crisis of the appellate body. We don't have an appellate body, but everything else at the WTO kind of works. It's just a matter of what do we do? Do we try to resuscitate the appellate body? Now, Marissa, the lawyer that some of you met at the WTO, told you, oh, we're looking into arbitration. Well, good luck, because arbitration is in deep, deep trouble right now. So there are several processes of reform. The main one is the one that is going on in UNCITRAL Working Group 3. If you ever read this, UNCITRAL Working Group 3 is working on reforming ISDS in general, ICSID, non-ICSID, in general. And here are some of the key criticisms. It's lengthy and costly, very costly. You see, average duration, average legal costs. Those are the costs to pay tribunals, to pay the legal fees, to pay the administration of the procedure. That's just that. The compensation awards, so the amount of the awards, there is no limit. It's no limit. It has skyrocketed. I think, again, the highest should still be the UCOS award, which was more than $50 billion, which Russia, I think, has not paid yet, never probably will. But they're huge. And imagine, you might be, maybe you're a country that doesn't even have that as a GDP, What do you do? The bankrupt, countries can go bankrupt, but there's a limit. So those are two strong criticisms. But there are others. This very big one. It has created a whole industry. Now, there are some that are kind of proposing, for example, having a multilateral court. The EU has proposed this. Instead of having these arbitrators and these tribunals, let's have a court where judges are nominated for a certain term. They get a salary, because now, of course, you can get paid very much and you can collect many arbitrations. So there is an incentive of having many arbitrations. Instead, the idea is and that contributes to the high costs. So in order to lower the costs, some of the suggestions is let's have a multilateral court of standing judges. They're always there and that decide the cases. You also have issues issues maybe with impartiality or independence of some of the arbitrators. It's not always the case, but there are sometimes, concerns that may arise. Some arbitrators, being arbitrator is not a job. arbitrators have jobs. And some are professors here, and I think that some of the best. I like academic arbitrators. Some are lawyers in firms, and maybe they have at the same time, they are arbitrators in a couple of cases and they're lawyers in a couple of cases. So that doesn't mean that they will be necessarily influenced into how to act as arbitrators, but some have raised the concern. What if maybe they're not so independent, no, they're not so impartial, because the decision in a certain direction might help their firm in other cases, no? Double hatting, we call that. So there's a lot of criticism there. There is an issue with the financing through third-party funding. One of you was asking me a few sessions ago, right? This is a big problem, and this has helped. You know, I did some reading on that, by the way. There's quite a lot of statistics that show how more third-party funding. So these are third parties that basically invest in disputes. They say, I'm going to fund your dispute, investor. If you bring the case, I'll pay for it, but then I get a chunk of the award. And there are all these studies that show you that cases have increased since this third-party funding has begun, and so it awards maybe too, but so this is a practice that we don't see anywhere else. Something that is very dear to this NGO, ISD, but also to environmentalists, human rights advocates, advocates for indigenous people's rights, is the fact that a lot of stakeholders have basically no role in these proceedings. You know, some of these investments affect local populations, affect sometimes indigenous people, affect a lot of other elements, but all you can do is sometimes submit an amicus curiae brief. You don't have other ways to influence the proceedings.